Okay, so we are recorded. Again, everyone else is in mute mode. And Bridget, please take it away.
Okay. Good morning, everyone. Thank you so much for participating today. I hope that you are all well. I think we're all a little webinared out at this point, but it is very important to stay connected. And I hope that there will be something that we say this morning that will be helpful to you and your business. Thank you very much, Brittany, for allowing GreenbergTraurig to provide this webinar today. And thank you for that very kind introduction. One of the things that means the most to me, of course, is being recognized by the Chamber last year, and I thank you for that also. I want to introduce my colleague, Lauren Whetstone, who is also presenting today. Lauren is a litigation shareholder in our Palm Beach County offices. She focuses her practice in the areas of complex commercial litigation and securities litigation. She has broad experience representing domestic and international clients in state and federal courts, as well as before the American Arbitration Association and FINRA.
Good morning, everyone.
I'm very proud to say that I've worked together with Lauren for many years now, and she has received many recognitions for her leadership. She has been a super lawyer since 2017 and was recognized as a Rising Star 2017 through 2019. She also won the Professional Excellence Award from the Daily Business Review in 2018 and has been listed by the South Florida Legal Guide as a top up-and-comer 2020. She also won an award from the Executive Women. She is on the board of directors of Healthy Mothers, Healthy Babies Coalition of Palm Beach County. And I understand that we have a representative on the phone from Healthy Mothers, Healthy Babies. Is that correct? I don't know, Brittany, can we talk back and forth with our listeners or not really?
I have them on mute as of right now.
Oh, okay. Okay, well then we'll move on. Welcome again. This is a time of opportunity as well as challenge. And we would like to focus today on the opportunity. There is tremendous opportunity for innovation at this time for us all to take a step back and improve on our processes, modernize and advance productivity. It's also a time of investment, to invest in our social capital as well as our human capital. And it's a time of ingenuity, to hire for skill, initiative, and resourcefulness. It will become, again, a time when employers, they talk about the buyer's market. And for a while, with such low unemployment, it has been sometimes difficult for employers to attract the best candidates. And there should be significant opportunity out there, both to improve on existing workforce capital and also to engage new employees. Following this introduction, you will be given the opportunity to launch onto the GT webinar, and at any time, whether after this presentation or any time that you have free time, we invite you to go to the GreenbergTraurig website. It's https://www.gtlaw.com/en for English. And you can click for updates from GT's Health Emergency Preparedness Task Force on Coronavirus Disease 2019. We invite you to go to that site because literally on a daily basis, things are changing. And many times your questions are the same questions that other GT clients have had and that we are responding to on that website. You can also click, once you're on that website, you can click to subscribe. And when you subscribe to receive the COVID-19 updates from GT, then you will receive updates through our alert system relating to the CARES Act and economic stimulus information, as well as our alerts and blogs on specific topics, and also information relating, they call it situation updates, but that gives you resources relating to federal, state, and local governments. Lauren and I today are going to talk to you not specifically about COVID-19 or the CARES Act, et cetera, because again, your best source of that information is to go onto the website to get the most up-to-date information. What Lauren and I would like to talk to you today is about what I'll call peripheral issues. Many of us are addressing issues in the workplace in terms of keeping our current employees employed and engaged, and then at the same time looking to the future. And so we want to remind you of the existing framework in employment laws and things that may not have occurred to the employer at this very challenging time. Florida is an at-will state, and employment is at will as compared to contractual relationships in which an employee can be dismissed by an employer for any reason, that is, without having to establish just cause for termination. And an employer can terminate an employee without warning, so long as the reason is not illegal. And of course, that's the catch. You have to make sure that the reason that you're terminating is not illegal, although, so a lot of times the catchphrase is you can let someone go for no reason, but you can't let them go for the wrong reason. And so that can be challenging at times, especially at times like this, to make sure that you are not running afoul of any of the federal, state, or local laws. And this takes, you need to take these federal, state, and local laws into account in hiring and in firing and in making employment decisions. So I think we all know that it is illegal to discriminate against someone, whether it be a current employee or an applicant for employment, because of that person's race, color, religion, sex, including gender identity, sexual orientation and pregnancy, national origin or age, which is 40 or older, disability or genetic information. It may also be against the law to terminate an employee for exercising their rights, such as rights that the employee may have under the Family Medical Leave Act, the Fair Labor Standards Act, or other federal and state employment statutes, such as workers' compensation laws and whistleblower statutes. It can also be challenging because employees may take the position that even though they didn't have a written contract for a specific term of employment, such as 1 year or 2 years or 5 years, that they nevertheless had an implied contract. So for example, an employee may take the position that in their job offer, the job offer stated that they were being hired at an annual salary of X amount, and that they moved from some other state to come to Florida to take this job, and believed from the wording of the job offer that they were guaranteed at least 1 or 2 years, or whatever that they can make out of that job offer or employment offer letter. They could take the position that that created an implied contract or a contract for a specific term of employment. So you want to be very careful in any of your job offer letters. Similarly, as we're all scrambling, again, to keep communications with our employees open, to reassure our employees, and to continue the good relationships that we've built with our employees, you want to be very careful about the wording that you use, because although you want to be reassuring, you always want to be careful as well, because you don't want to create in their minds what they think is a contract or a guarantee, for example, that they won't be laid off. The other area in which implied contracts can arise is with the employee handbook. Again, this may be an excellent opportunity for all of us to go back and look at the employee handbooks we have in place and make sure, particularly after this event, that we feel that we're covered for various emergency situations that may arise, what our policies are going to be. And of course, I think we've all learned that working from home is probably going to be much more common going forward. People have now gotten used to it, and we, I think, all need to be prepared for a lot of work to be done remotely. So in your employee handbooks, you're going to want to look over the various provisions that may relate to that kind of thing. So for example, what technology the employer is going to provide and what technology the employee must have in order to work at the company. In other words, does the employee have to have access to a laptop or a desktop at home? Those kinds of things. Look through your employee handbook, think about things that may be implicated now, and another key area is confidentiality, and we'll cover that a little bit later. But those kinds of provisions in your employee handbook, take a look, see if you have any questions, and see if it might be time to update your employee handbook. The Fair Labor Standards Act and the Florida Minimum Wage Act are also key laws that you have to consider as everyone transitions and tries to look for a path forward. I think a lot of us are trying different things, such as instead of laying off a certain number of employees, considering pay reductions. Sometimes it's the people at the top that are taking a pay reduction so that other employees do not have to have a pay reduction, and so that some people aren't laid off. You have to take all of the factors into consideration in connection with existing Fair Labor Standards Act and Florida Minimum Wage Act laws. I find that a very helpful tool is to use the United States Department of Labor fact sheets to give an overview, for example, of exemptions. So there are exemptions from both minimum wage and overtime pay laws. And I think most of us are most familiar with the exemptions for executive, administrative, and professional employees, which would include teachers, academic, administrative personnel in elementary and secondary schools, outside sales employees, employees in certain computer-related occupations, et cetera, all as defined in the Department of Labor regulations. There are also exemptions for certain seasonal amusement or recreational establishments, newspapers, seamen, fishing operations, newspaper work, for example, and then, of course, farm workers. And there's also exemptions for casual babysitters and persons employed as companions to the elderly or the infirm. Whether you fall within one of those exemptions pre-COVID-19 may be now impacted. So for example, under the executive, administrative, and professional employee exemption, some of those exemptions depend upon the individual who you are seeking to classify as exempt supervising a certain number of employees. As many businesses are expanding the role of employees to cover new opportunities, or because they must, they're downsizing. These exemptions may change. So for example, if because of the COVID-19 situation, you must let an employee go, that may mean that your previously exempt employee is no longer supervising 2 or more full-time employees and becomes non-exempt. So you have to think about all of those things, carefully, both as you're making your decisions, and then also to make sure that after the decisions are made, you're complying with both federal and state law. Also, to qualify for exemptions, employees under the Fair Labor Standards Act, employees generally must meet certain tests regarding the job duties and be paid on a salary basis as defined in the regulations at not less than $684 per week. So that was revised recently on January 1st, 2020. Prior to that time, it was actually significantly lower. It was $455 a week, or approximately $23,660 a year. Now with the $684 a week, it's about $35,568 annually. That said, again, as many of us are trying to adjust and keep most of our employees on board and develop our capital, we need to be mindful that if we are cutting any salaries, we need to be careful that we don't fall below the thresholds to qualify for the Fair Labor Standards Act exemptions. So again, with this, what has been referred to me a number of times as the new normal, under the new normal, this is really a very important time for you to review job descriptions, your staffing decisions, your pay decisions, and then as a segue into the next topic, your timekeeping and record-keeping decisions. The Fair Labor Standards Act requires record keeping. And the record keeping requires that employers keep records on wages, hours, and other items as specified in the Department of Labor regulations. The records do not have to be kept in any particular form, and you don't have to use time clocks. However, as the employer, you do need to be able to prove, essentially, a number of things. And the key point, of course, is the hour and day when the work week begins and the total hours worked each work day in each work week. This is because if it's a non-exempt employee and the employee works more than 40 hours in any work week, you're going to have to pay overtime. This may become challenging as your workforce is working remotely from home. So you have to determine what is the best way for you to keep records of, the start time, the end time, break times, etc. And you should also put in place a mechanism, a back and forth check. So for example, whether it's that you send an email to an employee at the end of the week saying, you have recorded X number of hours this work week, please confirm, and then they send you back an email confirming. And then you need to track it. Just like anything else, if you have a system in place but you don't enforce it or track it, then it's worth nothing and could actually be worse than having no system at all. So there are things you might want to consider, particularly remotely. And actually, Bridget talking about it, it seems that with so many of us working from home, the days seem to start to blend together with the evenings and the nights, and we may not either put boundaries on ourselves or acknowledge boundaries on our employees. So we have to be very, very careful, for example, that an employee, because something popped into our head at 8 o'clock at night and we sent an email or sent a text message to the employee, which they ordinarily wouldn't have seen until the next morning when they reported to work and were on, the system at work. But now they do see it at home because of, the connections that we put in place so people can work from home. It has to be very clear that they're not expected to, for example, respond to that email or do anything about that email that evening, because otherwise you're going to run into this overtime issue. So again, the key part here is to make sure that you're, very clear at the management level of what the expectations are, and make sure that you clearly express that to your employees, and that you are keeping good records on time worked for non-exempt employees. The next area that comes up, and Lauren has special knowledge in these areas, is the safety and security of our confidential business information during this time when many of our employees are working remotely. It's very important, again, whether it's through separate confidentiality agreements, separate policies and procedures that are written and delivered to the employee, or in our employee handbooks. It's very important that you identify to the employees what the business considers to be confidential information, what the restrictions are on an employee's use of confidential information, particularly and especially anything that the company treats as trade secret. And you need to make sure that all of your walls are in place so that only certain people have access to that trade secret information, and that it's, for example, password protected. And you also want to be mindful of competition and things that you may do, and we're all doing that, and I don't want to mention any particular technology, but a technology that may be more difficult or less difficult for people who are not actually invited to attend and get information. We need to be very careful, again, when we're setting up those kinds of meetings, virtual meetings, that it's, for example, password protected, and that you have a clear understanding of who's participating in the call. So again, this is a time of extraordinary opportunity, and we just wanted to give you some pointers in terms of using the opportunity in a very mindful way, both in connection with your human capital and social capital. Again, excellent opportunity to have your employees reach out to current and potential clients and customers, to keep those communications open. This is a time I think we'll all remember and appreciate people that reached out to us. So again, great opportunities, but please be mindful that there are also still limitations under federal, state, and local laws that we can use to our advantage, but also we should be very mindful of. So with this, and because we've invited you to participate in the webinar, which is, I think, about 30 minutes, we'll open it up to question and answer. And thank you very much again for your participation.
All right, Bridget, thank you. So I just sent a message to everyone through the chat. If anyone has any questions, they can mention it through the chat, or I think there's a way that you could actually raise your hand if anyone knows how to use that feature within a webinar. There's a button for that under participants or chat, I can't remember. But Does anyone have any questions, maybe related to what they're going through right now?
Brittany, while people are asking questions, I wanted to use this opportunity to do a shameless public service announcement. I'm on the board of directors of Legal Aid of Palm Beach County, and Legal Aid is a Palm Beach North Chamber member. They provide, in addition to other services, and I invite you to look at their website, not only because it may assist employers in helping their employees find services, but also because I know that we do have some not-for-profits on the line, and Legal Aid provides a nonprofit legal assistance program. There is an annual fee, but it's minimal, and they provide in-house legal services to the nonprofit agencies that serve children and families in Palm Beach County. So I invite our not-for-profits to consider that as you know, a potential asset, and just give Legal Aid a call. I think it's Vanessa Coe that is heading that up right now, and it may be, you know, something you want to consider.
No, that's wonderful information to know, and I know everyone will appreciate at least that knowledge that that's an option for them. Okay, so I don't see any questions on, oh, yes, right as I say that, of course. Okay, so you mentioned the age discrimination is for 40 and older. Are there any regulations related to discriminating for under 40?
So in other words, if you're letting your young people, there is not, the ADEA specifically prohibits employers from discriminating based on age, whether it's hiring, promoting, discharging, etc. People who are age 40 or older. There is not a similar statute for 40 or for under age 40. Again, you have to be very careful, though, that the individual doesn't fall into some other category. So, for example, if it just so happens that I think employers typically will also look at seniority, how long. So, in that model, it is not unusual for the less senior individuals to be also younger. But you also have to be sure, for example, if the last 3 people that you've hired, all of who are under the age of 40, happen to be female. And so now if you're letting them go, does that discriminate against, is that gender discrimination? So you have to be very careful and look at the, look at the picture, look at the big picture, and, just make sure that you're making well-reasoned decisions that can, be supported based upon your business model.
Okay, wonderful. Another question, what if you told your employees 3 weeks ago that you wouldn't be letting anyone go? Things have changed now. How would you be able to best protect yourself from this implied contract consideration?
So I can't give a blanket answer to that, particularly under, the COVID-19 legislation, and that is a very, it has so many factors that would go into the answer. I don't know who asked that question, but please feel free to reach out to me. I just need to know a lot more facts in order to respond to that question. But yes, sadly, a lot of employers are dealing with those kinds of questions because everyone had the best intentions at the beginning, and certainly I don't think any employer was hoping that, you know, this would continue on, and it looks like it will continue on further. And so sadly, I think a lot of employers are in that boat. But please feel free to call me. My number is 561-650-7912.
You know, excuse me, one question I had, I have personally never heard the term furloughed until about 4 weeks ago. So could you maybe just give a general description of what furloughed means and why an employer would want to furlough their employees as opposed to, I guess, laying them off or firing them, or, you know, what are the differences in that?
Sure. So again, anything that I say is overridden by anything that is on the GreenbergTraurig specific COVID-19 task force, which is on our website. And again, I invite you to look at, you know, to review that webinar and also look at the materials that we have posted on the website. Secondly, I think a lot of employers, again, possibly, unfortunately, have already crossed that bridge. As indicated by the prior question, this has been going on for enough weeks that employers have already had to make some decisions. And so it's most likely that employers have already made the decision of whether to furlough or whether to, you know, lay off, et cetera. That said, the general, very, very general, high-level difference between furlough and layoff is layoff involves an actual termination of employment. Furlough is more of a leave, and the employee continues to be, quote, employed, and then is called back after the furlough period without having to reapply for employment, et cetera. The differences have been, and again, that's very, very high level, you know, general layman's understanding of the two terms. Those differences have been, I would say, defined and possibly not so clearly in the regulations, for example, the CARES Act and stuff. So again, it is very, very important that you know, whether you're talking to your accountants, your attorneys, your HR advisors, make sure that the way the laws work, specifically with your workforce, you know, because again, that's a big point. You need to make sure that your workforce, you know, qualifies under these acts. But generally speaking, that's the difference, that there is a termination of employment in connection with layoffs, where there is, I'll call it, again, in very high level general terms, a suspension of employment with furlough. And from an employee standpoint, one of the considerations is health insurance, which can be a huge consideration.
Okay, that was a very easy answer to understand, so thank you. We do have one more question. Does it make a difference for applying for unemployment? So you cannot apply for unemployment if you are furloughed.
Okay, so again, I have to refer you to the GreenbergTraurig website, which, you know, they are keeping that up to date and making sure that as new, part of the problem is that, you know, there are all these levels of law. So you have your federal law, your state law, your local law, and different laws interact in different ways. But generally speaking, it is correct that if you are laid off, then your employment is terminated, and you would be able to apply for unemployment compensation. But again, that is in the general pre-COVID-19 legislation world. So the best thing for you to do is to go onto the GreenbergTraurig website, look at your particular industry and location. I mean, obviously, we're all here in Florida and Palm Beach County, so that should be easy enough. And look at and see which laws will apply to your particular workforce and how that will impact your employees today as compared to what may be in effect tomorrow.
Very true. Wonderful. Okay. So I believe that answers all the questions that we have for today. So I just wanted to go ahead and thank everyone for their time, especially Bridget, Lauren, and Karen on the line. I appreciate you taking the time to offer this opportunity for chamber members so that they can kind of understand what they, kind of the route they need to take as an employer in today's world and with the situation at hand. So with that, I will go ahead and end the webinar. Again, thank you, Bridget, Lauren, and Karen, and everyone on the line for joining us. And Bridget and Karen will be reaching out to everyone with some further information that could hopefully benefit you and your business or your organization. So,
Brittany, we again thank you for all the work you did to organize this and facilitate, and thank you for all you do for all of the members, including GreenbergTraurig. We really value our relationship with the chamber, and thank you for all that all of you do for us.
Awesome. I'm happy to hear that. Great. Okay. All right. Well, everyone have a great day. Thank you. I'm sorry.
Oh, thank you, Brittany.
Yes. Awesome. All right. Have a great day, everybody.
Thank you.
Bye-bye.